Justice Wilfred Kpochi, the leader of the three-man-led panel that presided over the tribunal matter of Edo State between Dr. Aswe Igodao and distinguished Senator Mode Okpebolo on the 2nd of April 2025, and you gave verdict in favor of the APC candidate that he won the 2024 governorship election that was filled with all manner of irregularities, all manner of malpractice, all manner of misconduct, all manner of bypassing the electoral process. Now, Nigeria, on behalf of the Abuja School of Thought, and on behalf of Nigeria, and on behalf of the good people of Edo State, they said I should ask you, sir, how you came about your judgment. How you came about your judgment by passing the irregularities, overlooking the overvoting, overlooking the bypassing of the electoral act that guide our electoral process, by bypassing how the election was rigged. How did you come about your judgment? Please, you people should watch this video.
The ruling faulting the tribunal's decision to dismiss claims of overvoting and electoral irregularities on the grounds that the petitioners failed to present presiding officers and polling agents as witnesses.
The idea that the maker of the document is the only person who can speak to the form, or that the polling witnesses must be called, is a legal fiction with no grounding in Nigerian jurisprudence. The point Abuja School is worried about is the growing strategy of courts defeating the essence of the Electoral Act itself. The change in the Electoral Act is placing burden on INEC, the regulator of elections. The courts are placing burden on victims of electoral malpractices.
The think tank also alleged irregularities in the conduct of the Edo State governorship election, insisting that the tribunal failed to address key concerns raised by the petitioners.
In the election, INEC printed and deployed duplicate result sheets which were used to declare results that bore no resemblance to what actually occurred at the polling unit. This was, of course, established by TAP Initiative. TAP Initiative did extensive work and took the results to a forensic examiner in South Africa, and they confirmed that those were duplicates, they are not the real relationship.
They, however, urged that immediate actions and systemic reforms be taken to ensure that critical issues of electoral irregularities are promptly addressed.
What we are seeing today is that INEC has usurped the right of citizens to elect their leaders by declaring fake results. An implication of that is that electoral tribunals are now enabling INEC to continue to usurp the people's power and play rough through a crippling technicality that is wrongly applied.
There is no reason why any one of us should be excited about going out to vote in 2027 if these things are not addressed.
And many thanks to Joshua Marai there for that report. It's back to you, Dr. Sam Amadi. With that report and with your earlier submission, it begs to ask the question of what exactly would have been the definition of justice in this matter?
Good question. You see, the electoral jurisprudence is that justice should be that which gives back voters the right to choose their leaders. And so what that means is, now, if, as is shown clearly by the documents before the court, that there's a discrepancy, the procedure which the law has provided to safeguard the integrity of the electoral process was not followed, justice requires that the court themselves will say it's not followed, especially when the Supreme Court, in the case of Rufus Adoma, in the case of Burton against them, has said that these non-compliance are strict liability. Meaning, you don't need to always say that you should bring every agent in all the polling units to look. In the US, we saw the case in America. If the printout from INEC, which is a public document, shows that something was wrong, don't ask that I must produce somebody who was a witness, who was a voter from all the units. That is wrong. That is the problem with electoral jurisprudence. They are making it difficult for victims of fraudulent elections to overturn election. And the political economy of it is very simple. If you cannot win at the tribunal because the burden of proof is excessive, it means that both INEC and the politicians will continue to rig. But if the courts do the right thing by strictly saying this is fraudulent, you can't declare a result in your IREG, which is their safety framework for results. And then the result you declare is different. Results that are not signed by agents. And then you're asking the victim, the petitioner, to basically, if I gave the givers and gave the printout, they say, oh, because it wasn't operated. It's either could have auto-operated, and then the computer says, we don't know how to operate it. Isn't it a court who should have mandated INEC to do that? Meanwhile, the electoral access within 14 days or so to
justice with Kpochi,
must upload
the simple question they are asking you is this: how did you bypass all the irregularities, all the malpractice, and you spoke nothing about it, and you gave judgment? They are asking you, how will you leave the burden of proof to the petitioners concerning beavers and IREF, that they should go and they should speak about it, when they are not the one who manufactured the beavers or the IREF? And the INEC, who are the one, the operationals of the beavers, they are also the first respondent in the same matter. They are not called upon to come and open the beavers and explain what the petitioners are claiming. You spoke nothing about it. How can you bypass all of the irregularities and you gave judgment? They are asking you, how will you bypass the errors, the bypassing of the electoral process that guide the whole election in Nigeria? The INEC bypassed the electoral law and they conducted an election in Edo State. How will you bypass it and you gave judgment? How? That is the question they are asking you, sir. How can you give judgment by passing all the areas that were pointed out in an election? How can you bypass judgment? Areas where they say there is an overvoting and INEC failed to fill the necessary document to be filled in order to make that overvoting invalid. They refused to fill it because of how they were rushing to manipulate the election, and you spoke nothing about it. How can you give judgment in a tribunal matter where the number of accredited voters is less than the number of people who came to vote in a particular polling unit? How did you give judgment, sir? With Kpochi, how do you give your judgment? This is the question that the Abuja School of Thought are asking you, sir. How did you give judgment? How did you give judgment to a Edo State Tribunal matter? How did you give judgment? This is how you people want to cripple Nigeria. This is how you people want to cripple the whole of the country and give it to APC. How do you give judgment, sir? Or is it that they have filled your stomach? How did you give judgment, sir? How is it that gifts have blinded their eyes to see the truth in a matter, to give justice? How did you give judgment? And reading all the judgment that you gave, you spoke nothing about the irregularities. All you said is that they should go and present over 100 or 1,000 weaknesses that we speak about the irregularities in all the polling units. What a shame. Where the electoral law stated clearly that if the beavers is present, you don't even need an oral witness. Sir, how did you give judgment? That is just the question. With Kpochi, how did you give judgment? You people have decided that you want to cripple Nigeria. You people, the judiciary has become, in fact, the number one trouble, the number one problem in Nigeria. Coupled with INEC. The number one problem. You people have become the ones who destroy our democracy. How did you give judgment? That is the question Nigerians are asking. That is the question that even outside Nigeria they are asking. That is the question that the Edo light they are asking you, sir. Shame. Shame on the judiciary in Nigeria. Shame on you people. Shame.